Robert Craig is the personal representative of the estate of Sheila Ann Halzari, deceased, versus Zhou Shen and Ping Hu, individuals, and Dearborn Federal Credit Union Corporation. Appearance for the plaintiff, please.
Good morning, Your Honor. Shannon on behalf of the plaintiff.
Good morning, Your Honor. Scott Murdoch, P46424, appearing on behalf of the defendants, Xiao Chen and Ping Hu. Dearborn Federal Credit Union was dismissed from the case, Your Honor.
Okay, thank you for that. It's a defendant's motion for summary disposition. Go ahead, Mr. Murdoch.
Yes, Your Honor. This is defendant's motion pursuant to MCR 2.116C7, a failure for statute of frauds, as well as MCR 2.116C10. In this case, this involves a land contract purchase by the decedent and her ex-husband. They entered into a land contract in 2009. While they didn't make full payments, including water and insurance during that time period, the defendants did not default them. However, it came to the end of the land contract period, in which case a balloon payment was due, and that was due in May 15 of 2014. At that time, the decedent and her husband were not able to take and pay the balloon payment. The land contract was in default. And
what were they paying? So we're talking a 6-year period here. What were they paying per month on the land contract?
The land contract payments were $650 per month.
And where's the house located?
And the house is located in Dearborn Heights on Drexel Street.
Mm-hmm. Okay, so they entered into, let me get the timeline correct. They entered into a land contract in 2009 to pay $650 a month, and they paid utilities. But when the balloon payment came in, May 15th of 2014, that they
were unable to
come up with the money, and therefore defaulted under the contract.
Correct, Your Honor. But instead of proceeding with either a forfeiture or foreclosure, the decedent paid $850 a month for rent. And then in October of 2015, the decedent entered into a new purchase agreement for the property, that it would be purchased by a cash sale for $65,000. The original land contract purchase price was for $84,000 in 2009. And so in 2015, she entered into and signed a new purchase agreement for the property, and that was supposed to have closed by November 30th, 2015. Now, that new purchase agreement called for the taxes to be prorated, and that the decedent would pay. In fact, there was a second addendum done that the decedent would pay a portion of the delinquent water, and that the defendants would also take and pay a portion of the delinquent water.
And then did they come up with the money at the closing?
And then, no, that's the case. They never were able to take and close upon that purchase agreement. And in fact, the decedent's husband, I believe that they became divorced, and subsequently he was deceased. And so the new purchase agreement was only with the decedent herself, who remained still residing in the home.
Okay.
So what's important to indicate, that I would say for the defendant's part, is that the new purchase agreement sales terms were for $65,000, not the original $84,000 that they intended to credit her for her payments that were made on the land contract previously.
But the plaintiff and both closing dates are the plaintiff could not come up with the money.
Correct. Yes, Your Honor.
Okay.
That would have been November 30th of 2015. So they were not able to close on the property and the
On
defendants.
that date, on November 30th, 2015.
Correct. And
Okay.
then the defendants then
They
subsequently.
pay the rent? Did they pay the $850 rent a month?
They paid $850 in rent, and then the decedent continued to pay $850 in rent until she died in 2022 sometime. I guess what would be important to indicate then is that we provided that from 2014 on, where the decedent paid $850 per month, okay, that the defendants would say is rent, okay, that all of the property taxes, all of the water utilities, all of the insurance were paid by the defendants.
Okay.
The plaintiff,
Here,
contests that there was a modification to the land contract agreement, but there's nothing in writing. Thus, our claim that it would fail for statute of frauds because they would have to have in writing some form of modification of that land contract, modifying it to, instead of rent being $850, that they increased it $200 a month to $850, and that was a modification that would be, instead of paying the balloon payment, was paid another $200 a month towards, I guess, the principal. But again, we don't know because there's nothing in writing.
okay, plaintiff's position, Ms. Worth?
Yes, Your Honor, we agree with many of the facts that the defendants claim. But what happened here is that there was the land contract that we all agree existed. We all agree the balloon payment was due. We all agree it wasn't paid. The defendants did nothing to enforce their rights under the land contract. They had the option under the land contract to declare a default. They had the right by statute to ask the plaintiff, the land contract vendee, for written verification that the contract was terminated. They didn't do that. They didn't forfeit the land contract. They didn't seek to foreclose the land contract. What they did is they executed a purchase agreement that was simply an executory contract. It didn't get fulfilled. Neither party complied, and all parties agree that the decedent then began paying $850 a month. And quite frankly, it's not a modification of the original contract. The amount went up, but what the contract provided was that the defendants were going to apply $200 a month toward the principal and the balance toward the outstanding payments. The land contract originally provides that the defendants have the right, the option to add any unpaid amounts, that were due for taxes, for insurance premiums, or water, added to the principal and collect it. And that's what they elected to do. They didn't do anything to terminate this land contract. And if the new purchase agreement were to substitute the land contract, then the defendants would have been obligated to notify the city of Dearborn Heights that the ownership had changed, because that would have then allowed the defendants to they would have paid a non-homestead tax rate. They didn't do that. They didn't rescind the plaintiff's homestead. They simply continued allowing her to stay there. She was making improvements to this property. She was still behaving as if she owned the property, because in her belief she did. And when she passed away, that was the first time that the defendants ever claimed, to my client's knowledge, that the land contract had been terminated. The decedent was still under the impression when she passed away that if she sold the property, she'd be getting the proceeds. So the parties simply continued under the terms of the original land contract, and the decedent was paying increased payments. We can all assume that may be because she didn't make the balloon payment or because she wasn't paying the taxes directly. But the original land contract actually contemplated that while the defendants were paying for the insurance, that the $200 would be applied toward the principal, and the balance would be going to the other payments that were due. And that's paragraph 10 of the contract. So that meets the statute of frauds. The parties simply continued under those terms with the decedent paying $200 more per month.
But let me ask you this. The plaintiff could not perform when the balloon came due May of 2014. They entered into a new arrangement, and then November 30th, 2015. At that time, the plaintiff was paying rent of $850, but could not come up with the payment to close on the deed. Correct?
Judge, we agree she could not come up with the payment to close on the deed,
Okay.
but the $850 was just a continuation of land contract payments. We dispute that those were rent payments. She never was treated as a tenant by these defendants or by anyone else.
Okay, well, she couldn't come up with a payment either time under the terms of the contract. Therefore, the title to the home remains in the name of the defendant. So the court's going to grant the defendant's motion for summary disposition, and Zhao Sheng and Peng Yu individuals will remain as the owners of the property. And I'm sure if I went to the register of deeds, that's what it would reflect. But plaintiff could not come up with the terms, so, and close. So the motion's granted. Defense counsel can submit the order.
Thank you, Your Honor. There is a remaining issue. There is a secondary count on behalf of the plaintiff for unjust enrichment, that although the defendants, there was never a demand made to them for seeking certain repairs that were made to the property, the defendants do acknowledge that certain repairs were made by the plaintiff after the death of the decedent to the home. Some of those are acknowledged, but there were some issues with whether or not, based upon an appraisal that the plaintiff had done to the property, whether or not they had been clearly completed or not. I believe that the defendants would stipulate to the original claim, which I think was approximately 5,000 something.
Well, I think that the claim remains. Your motion didn't pertain to those claims. This simply doesn't resolve the entire case. It simply resolves the quiet title.
Yes, yeah. But then the amount in controversy then would be lower than the amount of the circuit court's jurisdiction in this matter, Your Honor, because it would be, I think the original claim was 5,000 something. The issue would be is basically that we would stipulate to what was indicated in the complaint with the defendants, and they would simply make them a payment for that amount that they had claimed. I believe that we would resolve the matter, though.
Well, if they agree to that, that's fine. So.
Yeah. Unfortunately, Judge, we can't agree to that because counsel is aware that additional monies have been expended.
Okay. Well, in which case, then again, I guess the issue would be is it doesn't meet the jurisdictional requirements of the circuit court any longer, and that Your Honor would then transfer it to the district court for resolution of that claim.
I can't transfer because the removal statute was repealed in 1996. I can dismiss this claim and they can refile in district court.
I believe then that would be the proper method of dealing.
Yeah, I'll dismiss it and they can refile in district court, and any statute problems would relate back to the filing in circuit court.
Right.
So that count is now dismissed also.
Okay. Thank you, Your Honor, and I will go ahead and prepare an order on that. Is there anything further for us, Your Honor?
No, that's it. That concludes the hearing.
Thank you, Your Honor.